Good afternoon or good morning, depending on your time zone, or perhaps, Daniella, good evening for you. I usually am loath to be on the last panel of the day and to be one of the people separating attendees from the cocktails or dinner. But since we're doing this remote, it's less of a concern than ordinary. I am a partner in the litigation group at Morgan Lewis in Chicago, where a significant portion of my practice involves consumer class action defense. The rest of the panel will introduce themselves and give their background when we get to the first question. Today's session is on settlement of global disputes. You know, and for better or for worse, class actions have been a prominent part of the U.S. litigation landscape for more than a century. You know, as was the case in the last panel, if you talk with a plaintiff lawyer like Michelle or Arthur, you're going to hear that class actions are a wonderful mechanism. I'm sure Anthony may feel this way as well. Collective actions, class actions are a wonderful mechanism to give voice to persons whose individual claims wouldn't justify a lawsuit, but collectively they can force defendant corporations into providing financial redress and changing their practices. If you speak to a defense lawyer, you will hear that class actions are often lawyer-driven lawsuits that can turn dubious claims into bet the company exposures. But no matter what your perspective, there often comes a time in any collective action or class action litigation where we have to take off our litigation hat and put on our settlement or problem solver hat and help our clients resolve the problem and move on in a way that is palatable, or say equally unpalatable for all sides. For plaintiffs, it's an opportunity to achieve relief on behalf of the class, of the group. And for defendants, it's an opportunity to resolve once and for all a problem and ensure peace going forward. Given the nature of today's world, where corporations frequently do business across borders, more and more we are seeing the potential for class or collective actions in multiple jurisdictions over worldwide problems, whether it's privacy and data breaches, whether it is antitrust or competition issues, it's diesel emissions, you name it. There are issues that are no longer that can be segregated into one country or another. What we want to talk about for the next 45 minutes is how plaintiffs and defendants can work together once there is a decision to resolve a case, to resolve it in a way that achieves their respective goals. So for plaintiffs, to achieve redress for the broadest possible number of people, and for defendants to achieve finality and the ability to move forward and run their business. So although this is a sophisticated audience, to ensure that we start from a common point of understanding, I'd like to have each of the panelists talk briefly about their backgrounds and introduce themselves, but then talk about how class action or collective action settlements are handled under the different regimes where they practice. And Derek, perhaps we can start with you talking about the U.S. perspective.
Sure. Thank you, Scott. First of all, let me say thank you to the Global Legal Group for doing an extraordinary job to bring us all together in these very unusual times. It's a pleasure to have the opportunity to speak to all of you. My name is Derek Ho. I'm a partner at Kellogg Hansen. Kellogg Hansen is a litigation boutique firm. We're based in Washington, D.C. And I litigate class actions and other complex cases all over the country. Maybe somewhat unusually, we represent both plaintiffs and defendants in these kinds of class actions. So we look at these cases from both perspectives. As to multi-jurisdictional cases, as those become more and more prevalent, we have found ourselves collaborating more and more with foreign counsel on cases with a cross-border dimension. And because our footprint is exclusively in the United States, we always welcome the opportunity to establish new connections with non-US counsel. So we appreciate the opportunity to participate in this conference. As Scott said, settlement is where the action is in the vast majority of cases in the United States. The vast majority of all cases, including class action cases, are resolved by settlement. In the class action context, there are generally two kinds of class actions. One is known as a mandatory class action, where there's no ability on the part of the class members to opt out. An example of this would be a claim for injunctive relief. But most US class actions are what are known as opt-out class actions. Claims for damages are opt-out class actions. And so I'm going to focus my comments on those. Once a settlement is negotiated, and a settlement in this context would be negotiated between counsel for the plaintiffs, counsel for the class, and the defendant, often, to be clear, before a court has even determined that that class treatment is appropriate, there are three general steps for determining whether the class settlement will be approved. The first is what's called preliminary approval, which means that the court has to give at least a preliminary look at whether the settlement is fair, reasonable, and adequate, sufficient to justify taking the next step, which is to provide notice to the class and an opportunity for class members to opt out of the class or object to the class settlement. So there would be a notice sent out by mail, email, advertisements, and the like. And then there would be a time for class members to either indicate that they want to opt out or indicate that they want to object. And then the third step is what's called the final approval step, and that involves a settlement fairness hearing where the judge has to find that the settlement is appropriate, fair, reasonable, and adequate in light of a number of standards that are set out in our federal rules. That, for example, that the class representatives are adequate in representing the class, that the relief that's being obtained by the class is adequate, and other factors as well, including resolving any objections that any objectors may make. So that's the general framework under which U.S. class actions are assessed.
Thank you, Derek. And Daniella, I know you practice in the Netherlands, which is one of the leaders in terms of class and collective action law outside the United States. Could you give us an introduction to your background, but also talk about the settlement steps of a class or collective action in the Netherlands, please?
Thanks, Todd. I'm a partner at Linklaters, a global firm, and part of the firm's class action group and heading the Dutch litigation department. I've been involved in many collective actions that involve a Dutch angle, and usually a cross-jurisdictional angle. And some examples are on the Dutch side, the air cargo litigation and settlements in relation to those. And currently work in progress is the settlement proposal made by Steinhoff for all its securities claims and other claims in the wake of its $11 billion accounting scandal. You asked us in the preparation to really focus on the differences with the US system. So I won't delve into all the details of the Dutch collective settlement process, but really focus on those differences. And one of the notable things is who you can include therein. So what is the role of potential foreign injured parties? And there, during the course of this conference, we already heard references to the Morrison rule, etc. So it would be good to start there. In a situation where a collective settlement process in the Netherlands follows a collective action in the Netherlands. And when I refer to such a collective settlement process, it's called the WCAM, WCAM in Dutch. But I'll refer to the latest version of our collective action as just the Dutch collective action and the regime that applies as of the 1st of January of this year. What's important in the Dutch collective action, which determines also the scope of class members for a collective settlement that follows such class action, is that there's a new scope rule. And that scope rule is introduced to prevent that there is a, say, litigation frenzy in the Netherlands where there's really no real connection with the Netherlands. So it's key that it's this admissibility requirement is met on that it will happen at the end of the day with a sufficient close connection to the Dutch legal sphere. That does not mean that it's just limited to Dutch injured parties, but there has to be a connection. For instance, the majority of the injured parties needs to be residing in the Netherlands, or the event at issue has taken place in the Netherlands, or there's a Dutch defendant with a sufficient additional connection with the Netherlands. So merely a Dutch group company that was in no way involved with the event as issue is not sufficient for jurisdiction under the collective action. And this brand new admissibility requirement is already under attack in the case initiated by the Diesel Emissions Justice Foundation, because they consider this to be a violation of EU law. And for the watchers of class litigation in Europe, this is something to look out for, because it may lead to preliminary questions at the European Court of Justice. So when comparing the Dutch standards with the US class litigation standards for foreign injured parties like Morrison, Vivendi, there are three things that stand out. First of all, the collective actions in the context of securities claims are not per se limited to securities traded on Dutch exchanges, although the location of the exchange on which the securities are traded may be relevant in the connection of the scope rule I just referred to. And another difference is that the question whether a Dutch judgment in a Dutch collective action is likely to be recognized in jurisdictions is not relevant for the admissibility. And that's also different than I understand in the US. Another key difference, I think, in the compared to US is a stacked approach to opt-in and opt-out. For the collective action, or sorry, I should say the collective settlement court approval, there is an opt-out process. So after the judgment declaring a settlement collectively binding, there's a 3-month opt-out period. And it applies to any and all injured parties. So even in a limited fund situation, there's an opt-out possibility. So there's no Rule 23B1B type of non-opt-out limited fund settlement. Unfortunately, I should say, because that makes it really difficult for defendants that are in a distressed situation to use this court approval, the regular way, so to say. So what's the stacking all about? So you have an opt-out for the settlement court approval, but you also have an opt-in, opt-out process in the collective action that may precede such a process. An opt-in for Dutch injured parties, and an opt-in for foreign parties in principle, unless the court decides otherwise. And that's a brand new feature of the law, this opt-in, particularly for foreign injured parties. And we have to see how that will develop. The idea is that in certain circumstances, the defendant may want opt-out for foreign injured parties in situations to acquire finality, maybe the limited fund situation, or if there's a possibility that the judgment can ultimately be enforced and acknowledged throughout Europe, for instance. Well, and lastly, and but not least, I should say, with respect to the plaintiff's bar, those collective actions and collective settlements can only be entered into by qualified representative organizations, so a Dutch foundation or an association. And that's obviously an important limitation, an important area of attention for plaintiffs when they prepare their case, because these organizations will have to meet certain requirements on governance, funding, etc. Back to you, Scott.
Thank you very much. And then Anthony, finally, if you could give us some background. I know you practice out of London, you practice all over the place, but could you talk to us about the law in the UK and how it differs from the US and the Netherlands, so we can set up the rest of our discussion?
Thank you, Scott. Good afternoon, everyone. Welcome from what used to be my children's playroom. But as we've all found out in lockdown, we have to change to different circumstances. We're back in lockdown here in the UK, as I know a lot of my European colleagues are. And my big regret between our lockdowns is I didn't get better bookshelves. I've been doing a number of these events, and I'm being out bookshelved on all occasions. So that's between second and third lockdown. I'm getting some bookshelves. So I'm from Hausfeld, which is and I'm based in London. We're a niche litigation practice. We're in the States, we're in Germany, we're in Belgium, and we're in London. We specialise particularly in doing group and collective actions. As I'm sure you've heard, probably ad nauseum, for those of you who've been listening in to the conference, in the UK at the moment, our collective procedure is an antitrust or competition litigation only procedure. So it only applies to antitrust actions. And it applies on both an opt-in and an opt-out basis. And we have a number of actions that are before the Competition Appeal Tribunal, which is our specialist antitrust or competition tribunal, waiting to be certified. And as and when they do get certified, and as and when there are settlements, there is a route to settle those collective actions. After the certification stage in London is called a collective proceedings order. And once you've had a CPO, you can then have a collective settlement approval order. And that is a settlement reached between the class rep and one or other of the defendants, where they apply to the CAT and they seek to prove to the CAT that the settlement they've entered into is a just and reasonable settlement in order for the CAT to sign off and register that settlement. And there are a number of things that the court will look at in making that decision. It will look at what might happen on a trial and whether the outcome of that might well be higher. It will look at what happens to the unclaimed balance under the settlement, and I'll come back to that in a minute. And it will look to what the experts and the legal advisors say to the merits of the case. So it's expected that this is going to be quite a meticulous review of any settlement before the CAT signs off on it. There is also, interestingly, a procedure to apply for settlement before you've got a certification, pre the CPO stage. It has a slightly different name. It's called a collective settlement order, but the principles behind it are very similar. Some different procedural steps, but broadly what you're trying to do is show to the tribunal that it's a just and reasonable settlement. Interestingly, as in comparison to the States, no right of appeal from the tribunal signing off on a settlement as being just or reasonable. The two really interesting things I think about the process in the UK to date are, first of all, it hasn't been used 5 years down the track, and secondly, slightly interesting, hasn't been used because of this incentive about the balance. Because if you go to trial and you lose as a defendant, any unclaimed balance goes to something called the access to justice clause. So as a defendant, you lose 100 pence in the pound. If you settle, you have the ability to put a settlement before the tribunal that says any residue that's not claimed comes back to me, defendant. And as we all know, particularly in consumer claims, that residue can be very significant. So you would think that would have been quite a big driver to settlement, but it hasn't to date, I think, which is interesting. Very quickly, we also have the development, and I'm sure you've heard about this, of representative action process 19.6 in England. It'll be interesting to see how settlement works under that, not clear at the moment. And interesting how the English jurisdiction compares to other common law jurisdictions, such as South Africa and Australia. I think very similar, and what the courts are seeking to do is strike a balance and come out with a just and reasonable settlement. I'll finish there, Scott.
Very much. I will make one note of a difference that I'm sure Derek is thinking about as well, is in the States, in a settlement where there's a fund and there is money left over, you technically could agree to do whatever you want with that. It used to be that the defendants would push for a remitter. It will come back to them. But I think it's fair to say that the trend now is the courts do not like that at all, and instead want to set up some sort of a cypre process where there is an organization somehow connected to the dispute that gets the money. But at any rate, let's dive deeper into the issue, the strategic issues we're here to talk about, which is once you get past the fighting like cats and dogs, or like Democrats and Republicans, and decide to settle the matter, how do you set a settlement up in the jurisdictions where you practice or across jurisdictions to achieve the broadest resolution possible, where you sweep in the most plaintiffs and from a defendant's perspective, take every step you can to cut off any liability from going forward and resolve the problem? And Daniella, why don't we start with you, and then I'll ask the same question of Anthony and Derek.
Thanks. Yeah, you already mentioned it. From the defendant side, to which I will be talking, it's really key to look at the way to mitigate the remaining risk, because at all times there could be litigation in other countries, etc., etc. And there's, I think, the common interest, because the better risk mitigants are included in the settlement strategy, the more value the settlement has for the defendant, and thus potentially a willingness to pay a higher settlement amount. So from the defense side, I think first and foremost, you look at the countries in which the plaintiffs have initiated litigation. So in a way, that's a bit of a reactive strategy, reactive to the litigation strategy chosen by the plaintiffs. And later on, I hope that Anthony will give us some secrets on how to build the best litigation in the appropriate forums to get to the settlement. But as defendant, you're mainly responsive. In distressed situations, you will also look potentially at insolvency regimes that are available. If there are no limited fund type of arrangements for court-approved settlements, and also what the recognition will be of such creditor agreements beyond the borders in other countries. Then an important question is, in those jurisdictions where litigation has been initiated, are there regimes for collective settlements? And then look at the key features: opt-in, opt-out, to sweep in as many injured parties as possible, and also the acknowledgement of those judgments elsewhere. Then we also look obviously at the parties that are most constructive, because there are great differences between say state of mind and strategies of certain parties, and also whether they qualify. As I said, in the Netherlands, you need to be a foundation or an association to be able to use the collective settlement system. So only those that qualify are the key persons you want to have a conversation with. And then you try to estimate the geographic dispersion of the injured party group, and to see whether maybe there are jurisdictions in which there's no litigation yet, but where there are a big group of potential injured parties that could also be useful with regimes. Then the substantive law obviously is relevant to see whether you would prefer a global settlement, or rather make a distinction between groups. Like in the US, you have treble damages, etc., not in Europe, so you like to keep those groups apart. And then the issue of the statutory period of limitation. I think over to Anthony for the plaintiff's perspective.
Thanks, Daniella. Much appreciated. I mean, the first thing to say is settlement per se is never the guiding light of why one makes decisions about different jurisdictions to litigate in. Because the choice you're making is the best jurisdiction to litigate in that's going to drive the best settlement, not necessarily the jurisdiction that has the best settlement mechanism, if that makes sense. We have a real issue in Europe, and I'm going to continue to count myself as a European for these purposes. because technically we probably still are, and emotionally I definitely still am. But anyway, we've got a real problem in contrast to the United States at the moment, because in the US they've developed this MDL process on class actions, so that even where you've got actions started in different states, the system drives them together, so you end up with one bit of litigation effectively in one federal court in one place. In Europe, we do not have that mechanism in any way, shape or form. And what we've seen, and I'm talking particularly here about antitrust because it's particularly a specialism of mine, but what we've seen in antitrust is as more actions have grown and as more class or quasi-class procedures have grown, we get different litigation in lots of different jurisdictions brought by lots of different people, but without any means to coalesce that. And I'll use a practical example of this in antitrust, which is the trucks litigation, which is probably known to very many, where what you've got is you've got litigation in the United Kingdom, in Germany, in Holland, in Spain, in the Czech Republic, in Poland, all over the European Union. You've got litigation, and the litigation, even in different jurisdictions, is being brought by different groups. So there are 3 or 4 different competing groups bringing trucks litigation in Holland, ditto in Germany, ditto in the UK. There are 2 competing collective processes in the United Kingdom under the rule. We might, I don't know, see one in due course in the Netherlands. What that means is, if you're trying to, from a defendant perspective, trying to settle that litigation, the trucks litigation, on a pan-European basis, it's extraordinarily difficult to do, because you've got to coalesce litigation in different jurisdictions brought by different groups and bring them together. Now, there is one potential silver lining to the cloud here, which is the Dutch settlement mechanism, which has been used particularly in securities litigation to bring closure on global class actions and global litigation. But there are, I think, practical difficulties with that. There remain real questions about whether judgments of the Dutch court on a settlement basis will be recognized in other jurisdictions. And there remain very real questions about whether, as a matter of practicality, people would not simply opt out of a Dutch process and continue their litigation somewhere else. But it is the only avenue and attempt at the moment in European terms to have one forum where you might try and resolve these issues. Now, of course, this is simply talking about this on a pan-European basis. Once we start adding in the difficulties of litigation in the United States or in other jurisdictions, then we've got very real issues indeed about how one can achieve a global settlement from a defendant point of view. I'm going to finish there and hand back to you.
May I ask a follow-up question, which is, in the last panel addressed this to some extent. In the U.S., even in a case as MDL'd, and for those of you who don't practice in the U.S., there's a mechanism where similar cases on the similar subjects are consolidated for discovery purposes in a single court. But is there, as a practical matter, any effort among the plaintiffs' lawyers in, for example, the trucks litigation to try to work together to try to settle? I mean, at some level, you have common interest. At some level, everybody wants the larger piece of the pie. And I just wonder, as a practical matter, how that works.
I'd like to say to you, Scott, that we were a seamless team on the claimant side, all acting in complete unison and union. That's not the case. There is an element of cooperation and collaboration and information sharing between claimant groups, but the very nature of the way this litigation works in Europe means we're also competitors, because we're each seeking to build groups of clients to bring claims. So it's a difficult dynamic. Maybe I should just leave it at that.
Yeah, and if I may add, I think what's really lacking in Europe is, say, a uniform class action regime with a lead plaintiff type of concept. Because if you're, as defendant, faced with various actions throughout Europe, whether it's group action or collective action, then you have to deal with all these groups. And sometimes, say, the infighting, as we then see it as defense counsel among the plaintiffs, make it extremely difficult to get in an efficient manner to global settlement.
Yeah, and I think it's really interesting that, Danielle, because one of the things that surprised me when I first started to learn more about US class action process 10 years or so ago was hearing defense counsel say, in some ways, we like the class action procedure because that allows us to have global peace. And we're in exactly that territory and water now in Europe, I think, where we don't have that process. And it's an impediment to reaching global settlements, or certainly pan-European settlements.
Derek, you have an interesting perspective because, as you said, Kellogg Hansen is both sides of the V. Can you tell us about how you go about thinking about, one is choice of forum if you're on the plaintiff side, and second is if you have a global problem, you mentioned that you partner with other law firms outside the United States, how do you go about thinking about how to settle problems globally to buy the best piece you can for your clients?
Thanks, Scott. As you say, we represent both plaintiffs and defendants primarily in U.S. litigation. And listening to Daniella and Anthony, I certainly share the observation that the U.S. class action system is in many ways more conducive, at least at this moment in time, to resolution of global disputes, even though in many ways U.S. substantive law is becoming somewhat more restrictive in the way that it's applied extraterritorially. So I know that there's been discussion, for example, about the Morrison case, which limits the applicability of U.S. securities law to securities transactions that occur outside the United States. And you would think that that means that it would be difficult in the context of a U.S.-cited class action settlement to sweep in securities transactions and resolve claims with respect to securities transactions that don't meet the Morrison standard. But to the contrary, the post-Morrison case law actually has had a tendency to permit, as part of a settlement of a class action relating to securities transactions, resolution even of claims that would not have been able to be brought in the United States. So, for example, in the Petrobras securities litigation, there were claims that were asserted that I think were pretty clearly barred by Morrison. The claim was simply that because the transactions were cleared by the DTC, the Depository Trust Company, that had a sufficient nexus to the United States. I think that's pretty clearly not correct. So these are claims that would be barred by Morrison, and yet in the settlement context, the courts were willing to sign off on a settlement that included the resolution of those Morrison-barred claims on the rationale that really plaintiffs and defendants should be able to agree to resolve claims even if they're not substantively meritorious. Another example of that phenomenon is the Verifone class action litigation, where again, this was a securities fraud case. The stock was traded on multiple exchanges, and there was a class case that was brought. The class case actually at its inception made no mention of claims related to transactions on foreign exchanges, but when it came time to settle, because both plaintiffs and defendants wanted to have a global resolution, the settlement was defined to include transactions on all exchanges, both US and abroad. And there was actually an Israeli investor who had commenced his own class action in Israel that came forward and objected to the settlement on the ground that, at least in his view, Israeli securities law was actually more plaintiff-friendly, and therefore a resolution of all claims, both US claims and foreign claims on the same terms, was unfair to foreign investors like himself. And the court overruled the objection and said that the global resolution, again, including of claims that could not have been brought under Morrison, was fair, reasonable, and adequate. So you can see that there is this kind of, I would say that there's, generally speaking, but especially in class actions, this pressure that courts feel to approve of these settlements and really to give both plaintiffs and defendants what they want, which is the broadest possible piece, even when that piece extends beyond what US substantive law would permit.
The things that this probably makes me a very boring cocktail conversation, but that I find fascinating about the US class action system is because it's an opt-out system. If you do nothing, whether you participate and take money in the claim or not, you lose the right to bring the claim. And it's a very, very interesting issue when the claimant is not in the United States and perhaps is not otherwise under the jurisdiction of the US courts. I wonder, Daniella and Anthony, if you might react and think about or tell the audience about your thoughts on this issue of trying to use US settlement to sweep in claims that have some connection, but yet probably very arguably are have a closer nexus to some other jurisdiction. And I'll let either of you react to that first.
Daniel, do you mind if I just go first? Because I think, Scott, we are seeing increasing use by defendants of this as a sword in US class settlements in two ways. First of all, in the way you identified, which is if you broaden the class that's settling and people don't actually come forward because they're either not aware of it or they choose not to, then you've set up an argument if they subsequently bring European litigation to say that they potentially settled in the context of the US litigation, and allied with that is defining the breadth of the settlement very widely. So that European claims potentially come under the bailiwick of the settlement. So when people do settle, the rubric catches them. So I think it is, for me, it is definitely a defendant tactic to use the US class action breadth of settlement in order to curtail claims elsewhere in the world.
Yeah, Anthony, I think I could say the same for the Dutch system in that respect, because it can work in a similar way. There have been examples of Shell and Converium where indeed there were settlements in the Netherlands with sometimes you could debate what the nexus was with the Netherlands, but then the courts were quite liberal in accepting, first of all, jurisdiction, and then also determining that the representative organizations were sufficiently representative also for the foreign injured parties. And then you can indeed use it as a sword in that respect. I think in a way the Dutch legislator has tried to cut back on that, the new system for the collective action at least. Because there, if you follow the collective action and then go to court-approved settlement process, then really the scope of your settlement will be determined by the scope of the collective action. So that means you have to apply the scope rule and look at the opt-ins and opt-outs. So it may be that some plaintiffs will try to avoid that and avoid the Dutch collective actions, and instead they will use other methods to litigate in the Netherlands, like on an assignment model where they buy claims from claimants, like claims from Europe does in the Air Cargo and the Steinhoff case, or to start litigation on behalf of the individual plaintiffs, their clients, like Renton Eisenhower and Deminor are doing in the Steinhoff case, or even go to a different country and then come back once there's settlement horizon to get court approval in the Netherlands.
Thank you.
Just one further observation. I think it's true, as Anthony says, that defendants are motivated to try to expand the scope of the relief that they're getting in U.S. class actions to include even releases with respect to foreign claims. But it's also the case, I think, that many U.S. class action lawyers are share that same interest because, of course, to the extent that the releases are broader, one would expect that the relief that's provided to the class is going to be broader. And so to the extent that that affects the attorney's fees that the plaintiff's lawyers get in the U.S. cases, I think there's really a kind of convergence or an alignment of interests that's leading U.S. courts to take a broader and broader view of its role in resolving these multi-jurisdictional problems.
We're getting close on time, but let me throw out one last topic for everyone to comment on, and I'll set it up by telling a story about when I clerked for a judge right out of law school, and parties would present an agreed protective order, which would govern, how documents could be disseminated in litigation. And my judge was very much said, you can agree to whatever you want, but I'm the judge and I have to sign it, and so I'm going to review this, and it's really, at the end of the day, it's my order. In the various jurisdictions where you practice, a couple of questions. How active are the judges in scrutinizing, the courts in scrutinizing the settlement for fairness? And what other players are involved? For example, in the US system, we have objectors. In certain types of settlements, state attorney generals can be involved and weigh in on the fairness of the settlement. Well, I'll throw this out to the group to talk about other practical issues that come up in global settlements once the plaintiff and the defendant have come up with the scheme that they present to the court.
Scott, let me just go first on that. The first time I really met a US federal judge was when I was on a mediation course in former Yugoslavia about 15 years or so ago, and it amazed me when his opening talk about mediation was how he liked to get his hands dirty and encourage the parties to come into mediation and get involved in the entrails of the mediation, because that is so far away from the tradition of the UK judiciary. Judicial activism in that sense just does not exist in the United Kingdom. Judges never get involved in settlement. They think it's entirely something to be done by the parties. So this is going to be a real challenge, I think, for UK judges when they're asked to look at settlements and get involved in them and judge them and try and work out whether they're sensible things or not, because there is just no tradition of that at the moment.
Yeah, in the Netherlands, it's quite different, I must say. So we've seen in various collective settlement processes that the court took a very active role, looking at the fairness and also the fees for the plaintiffs' organizations, where, for instance, in the Fortis case, the fees of one of the representative organizations were not, certified. So with respect to that organization only, the settlement was not declared binding. And on the one hand, you could consider that as a good development because the court then develops the law, etc. But in practice, I think the courts are making life very difficult for defendants, because we do know that certain plaintiffs groups, particularly commercially driven and with litigation funding behind it, they shy away from that court scrutiny, particularly over their fees and the distinction between active and non-active claimants. And at times they are really driving companies towards private settlements, which in my view can only work if the type of damages claims that they've put forward are not better company type of claims, because then you really need finality as a defendant.
Thank you, Daniella. And Derek, could you touch briefly on the US, which is, at least from my perspective, the scrutiny that judges are giving to class action settlements is really, especially in certain circuits, is becoming much higher. But what is your perspective?
Yeah, I think that's right. As I mentioned at the outset, there is built into our rules a requirement that the court find that a settlement be fair, adequate, and reasonable. I think there's a wide range of attitudes toward that requirement. On the one hand, as Anthony was saying, by and large, in the context of private settlements, courts have no role. And I think there are some judges who are of the philosophy that if both the plaintiffs and the defendants have signed off on a settlement and there's no objection, that it is, very difficult to see why a judge ought to stand in the way. But I think increasingly there is a tendency toward greater scrutiny of even unobjected to settlements. And just one final note about objectors, which Scott mentioned. Objectors do continue to play a very important role in the settlement process in the United States, for good or for ill. If there is a settlement as to which there is no objection, I think it is still the case that courts almost with some relatively rare exceptions, will approve the settlement, but objectors throw a big wrench into the gears. And so there has grown even sort of a cottage industry of folks that simply object to settlements as a way of holding them up and extracting, some value for themselves because of the difficulties that objections create.
That's certainly true, and one of the questions that's popped up is how are objectors treated or remunerated, and the answer is in many instances they're bought off. They're paid some amount to go away, but there are other objectors, particularly in the area of attorney's fees, who are objecting on principle, and they do bring up issues that hold the plaintiff attorneys to their task of proving that the amount that they're getting as attorney's fees is fair, reasonable, and adequate. So we are out of time. Anthony, Daniella, Derek, thank you for your participation. I think it's been terrific. I believe here comes Florjan. I think they'd asked that we stick around to answer questions or move over to the networking area. And I'd be happy to do that as well. But thank you all for participating, and thank you for having us.
Thank you everyone who's listening. It was another great day and great turnout. And yes, Scott, thank you very much for directing everyone to the networking area. So we continue to use the platform. It's open until Friday evening, so you can continue to use it. The conversations are not going to cut short. It was another great day. Thank you very much.
Thank you.
Have a good evening. Have a good rest of the day.